Good morning, everybody, and welcome to our first virtual webinar under COVID conditions. My name's Elaine Hutley. I'm a partner at Irwin Mitchell, and I'm joined today by my co-host Helen Dyke, who's a senior associate in the team. We'd like to thank Michael Page, first of all, for co-hosting this with us. So you may have received your invitations through us, through Michael Page or other third parties or promotions. So thank you to Michael Page for your support in this. This has proven to be one of our most popular events, and I think that just shows the difficult times that we're working in. We've heard the phrase strange and difficult times, and as you look back, it feels like we've been in this situation for a long time, and there've been probably more challenges for HR professionals in the last few weeks than we normally experience in a year or more. And I say that as we are on the cusp of yet another change whilst we prepare for returning employees and the easing of the lockdown. So we've only got an hour today and we've got an awful lot to get through, but we're going to do our best to try and highlight to you the key issues and considerations that you need to have and what you might need to think about. Now, unfortunately, we're not going to be able to cover everything today, but we will do our best. And we've also, if you have any questions as we go through, please type them into the Q&A, and we will try and cover as many as we can as we go along. I suspect you're all going to have lots of questions, and I suspect we'll have some common themes, so we'll try and group them to cover as much as we possibly can. So what we're going to cover today is managing the process of returning employees to work and remaining operational, so as far as you possibly can. That involves risk assessments, which kind of takes us out of our comfort zone in HR and employment law because the landscape has shifted so much. We're also going to be faced with the possibility of a whole new strand of employment tribunal litigation. The legislation has always been there where employees feel that there is a risk to their health and safety in being at work, but the number of cases that we've previously had have been very limited, but potentially with COVID, those are going to come to the forefront. So we need to look at those to say, well, how do we deal with them? How do we preempt them? And then also recent surveys amongst the Institute of Directors and CBI have said that actually furlough was almost a breathing space or a stopgap. And for many businesses, either not having furlough there anymore or having to contribute to the cost of furloughing employees will mean that we're going to have to move into looking at more serious steps, for example, redundancies and restructures. So, as I say, a lot to cover for today. So, without any further ado, let's have a look and just recap at where we are and where we've come from. So it seems crazy really to think that we only started lockdown 23rd of March. You know, we're on the 1st of June today. 23rd of March doesn't feel like that far away when we look at a calendar. But when you look at everything we've gone through, my goodness, it might feel like you've gone through a year. It's important to remember, I think, that the government never ordered non-essential work to stop. So a lot of businesses have remained operational in whole or in part, and some have even had an increase in demand and have recruited. So supermarkets, delivery companies, they've faced very different pressures. And so we've experienced a full spectrum of effects of COVID. On the 13th of May, when the UK was encouraged by the government to return to employees to work if it wasn't possible for them to work from home, was when we first got that glimpse of reluctance and of not only employees but also unions or works councils starting to resist, to say, well, is this really safe? And I think that's what we're going to have over the next few weeks and months. That's where our focus is going to be, to say, well, how can we manage this situation? Today is quite a crucial day. So schools and colleges have been encouraged to open, and outdoor markets and car showrooms can also open. But there is going to be a short delay until the 15th of June until other non-essential shops can also open. And then looking further ahead is, well, what's the first step in ensuring that workplaces are secure.
And on that then, so the government's position is that no business should reopen unless it is COVID secure. So that's the new buzzword that everybody's talking about. But what does that mean? Well, it means that you have to take all reasonable steps to ensure that your staff work in a safe environment, and if you're identifying the risks, you're taking steps to reduce these to the lowest practicable level. You don't have to eliminate the risk entirely, but there are minimum steps that you must take, which includes following HSE risk assessment guidance. So that's absolutely critical that you look at that. So you're identifying what work activity or situations might cause transmission of the virus. You're thinking about who could be at risk, and you're deciding how likely it is that someone could be exposed. And then you're required to act to remove that activity or situation. And if it's not possible, then you're looking to control the risk as far as you possibly can. So the government guidance is, well, there's a lot of similarity between how these guides are worded. The basic rules are that if you can maintain social distancing, then you should do that. But if that's not possible, then you can only reopen if you put in suitable measures to control that risk of transmission. So that might include barriers in shared spaces. We've seen a lot of that in supermarkets, creating shift patterns. So you've got different teams working at different times. And if your business uses shared spaces, then you'll need to speak with your landlord and other tenants to identify and minimise that risk. There's lots of examples of the likes of supermarkets leading the way on this, where they've got barriers at tills, one-way systems, limiting the number of people that enter. And remember, with the guidance, it only applies to England, so public health is devolved in Northern Ireland, Wales and Scotland. So we're looking at the English guidance. And it is important to remember that it's still government guidance for employers to take all reasonable steps to allow employees to work from home. So that is key if you can do that. Obviously, we can help with reviewing risk assessments for you if you need assistance with that. So then looking at consultation and what you need to do around risk assessments, there's two sets of regulations that might apply in this scenario. And you've got them on the slide there. So these are designed to enable you to develop, maintain and promote measures that ensure health and safety at work, and check how effective those measures are. Now, if you recognise a union, it's really important that you collectively consult with the health and safety union representative. You must discuss your proposals to make your workplace safe. And if you don't have a union representative, or you don't recognise a union, then you do need to consult with your employees directly, as either as individuals or through a workforce elected group. And it is important that you think about consultation under both those sets of regulations. If you're not sure on what you should be doing, then obviously speak to us and we can help you with that. So looking at consultation in a bit more detail, consultation involves giving information and taking into account what either the union or the employees are saying before you make any health and safety decisions. The law doesn't state when you must consult or for how long, but it does say that it should be in good time. And in practice, this means that you have to allow time for your employees to consider the issues and provide informed responses. So consultation doesn't remove your right to manage. You are responsible as the employer for making the final decision. But if you recognise a union and they don't agree that it's safe, then obviously you've got the risk there of unions balloting and taking strike action if they've got sufficient numbers in favour of that. So you do need to proceed with caution. If you don't comply with the regulations, then you will be committing an offence. There is the risk of health and safety inspectors from either HSE or local authorities that may look to enforce the regulations where there's been no consultation or no evidence of consultation. So again, we can support you with those consultation requirements. You've got the slide there in front of you in terms of travel, so risk assessments around travel. We've already seen lots of press attention around crowded buses and tubes, and it's clear that social distancing can be impossible really for many that rely on public transport, particularly around London. So employers have to find out how staff plan to get to work, in our view, and that's something that you probably haven't had to think about before. But thinking around the health and safety legislation and your common law duty of care to take reasonable care for the health and safety of your employees, there is a breach or a risk of breach if the employee suffers harm and it's as a result of your actions and that harm was reasonably foreseeable, then there is that risk of liability being imposed on the employer. So we need to get it right. There's also the risk of the breach of trust and confidence, the implied term. So if that is breached and employees feel that they don't have trust and confidence in you as an employer, then you've got the risk of a constructive unfair dismissal claim if they resign. And then there's also the duty not to subject employees to a detriment or to dismiss them if they take action and they think that they're in serious and imminent danger. So the HSE guidance on this is a little limited. It says that employers should think about it, which means that you've got to identify where people can travel alone in their own transport, or they can walk or cycle. Obviously, that's the safest thing to do. And when getting to and from work, to maintain social distancing. So you do need to talk to your employees about this. Also think about entry and exit points. Can that be managed so that they're not entering at the same time or exiting at the same time? And think about hand washing facilities. So either they should be able to wash their hands, or you should be providing hand sanitizer. So our view is that you really need to do quite a lot, really. It's quite a burden on employers, particularly for employees that can't walk or cycle or drive themselves to work, because there is that risk of becoming infected and then spreading it across your workforce. The government has published safer travel guidance, so it's worth having a read of that. And that asks users to consider all other forms of transport before resorting to public transport. If there is no alternative, then obviously to maintain social distancing, and to look at travelling off peak, so that you might need to think about that with shift patterns, and also to wear a face covering and avoid eating and drinking. So think about with your staff, how do they travel to work? Do they have any particular concerns? Are they willing to attend the workplace if they have to use public transport? So again, speak to them about that, and look at each employee's individual situation, take account of their commute and their general health, and if you can, try and support other ways for them to get into work if that's possible. So then finally, on risk assessments, you need to be looking at the different categories of workers. So we've got them on the slide there. So particularly think about vulnerable people who may or may not be required to shield, pregnant women, BAME members of staff. So we know that there's increasing evidence that COVID adversely affects BAME people. And with pregnant women, obviously they have special rights. So think about, do you need to look at the right for them to be suspended on full pay if the workplace is not safe for them and there's no other work that they can be given? But those are the sort of categories that you need to be thinking about. Obviously, if anybody is still shielding, they must remain at home and work from home if they can. If you need advice, obviously do get in touch and we can help you with that. And then Elaine's now going to talk about the future and what that looks like for your organisation.
We are, but just looking at the Q&A, we've just got a couple of questions on risk assessments. So the first one is, we have clients asking our employees who work on their sites to complete questionnaires, including NI numbers and other personal data. Where do we stand regarding GDPR of this data? And also, what if a response such that they have a BMI over 40 or other pre-existing medical condition means that they are refused to work on their site?
So with GDPR, that is something that you need to take account of when you're looking at risk assessments, absolutely. But you've got a reason here for doing it. I think if you do it as part of your consultation with employees, then that is your legitimate reason for doing that. Obviously, ask as limited information as you can as possible. Speak to individuals and explain the reasons why you're asking for this information. So that will be key, I think, to make sure that you're acting in accordance with the GDPR regulations. If you've got specific concerns around data protection, we've got a specialist team that deal with data protection, so we'll be able to help you more with that.
I'd agree, and on that one I think it's slightly more complicated as well, given that this is a client who's asking employees, so I'm presuming there's some sort of service provision there, and I think that comes back to actually engage with your client and find out what their concerns are and what they're proposing, and see what they have under their data processing policies to say, well, is it covered? Do they need to update those? And it might be worth having a look at your commercial terms to see on what grounds they can turn your staff away. Because if you are providing staff to a client and the client refuses them, there's then a question for you of, can you deploy them elsewhere? What does your employment agreement with the individual say? If not, and they are saying they are ready and available to work, that might be a suspension on full pay. So a number of things to think about there, but hopefully that gives you a good starting point. Another question's come in. We have a shop manager from whom we have had little or no communication since we closed the shops, despite emailing and calling. We believe he has been struggling mentally with the situation, although he has not told us this explicitly. In order for us to reopen the shop, we need his input. How do we proceed if he refuses to communicate with us? Would we be within our rights to classify this as gross misconduct and move towards dismissal?
So I think you're doing the right thing in terms of trying to maintain communication with him, and you need to keep a track of that in terms of your attempts to telephone him, to email him, so make sure that you're logging all attempts. Ultimately, I think if you've tried phoning, texting, emailing, and you're still getting nothing at all, then I would write a letter to his home address, ask him to attend a meeting to discuss how he is, make it clear that you're doing this to protect him and to support him, so that you can say that you're concerned about his well-being and you do need to speak to him. And ultimately, yes, you could potentially look at a disciplinary process, but that I think would have to be an absolute last resort when you've tried all means of communication.
Lovely. And then we've got one final question. How do we handle members of staff who cannot work from home but refuse to come to work as they're concerned about safety travelling on public transport? So I think you've covered that to an extent, haven't you, Helen, with the guidance that the government have published. And I think we're going to answer the second part of that. So, well, what do we do if they refuse as we go through? So, was there anything else you wanted to add before we look at future on that, Helen?
No, I think that's we will come to that point in terms of what you do, but really it's a case of trying to reassure them as best you can, and then we'll talk about the measures that you can take if they're still refusing to attend work.
Lovely. Okay, so looking at the future, where do we go from here? We've got some information following Friday night's, I can't move my slide on, following Friday night's announcement regarding the future of furlough, and this is now going to prompt a lot of organisations, if they haven't already, to really plan for what this now means for you and your individual business. And there isn't a one size fits all. There are going to be lots of options available, and you have a huge amount of flexibility, which potentially is a good thing. So the first option is to continue to use the furlough scheme in its altered form, and in a second I'm going to talk you through what we currently know about how the furlough scheme is going to operate up until the 31st of October. Depending upon how you move things forward, you may need to look at changing your terms and conditions of employment. which again sounds really simple, but depending upon what you want to change and for how many employees, we might have to go through a consultation process. If the combination of a furlough scheme and changing terms and conditions isn't enough, we might have to look at redundancies and restructures. These might be collective if we're looking at 20 or more employees, and again we're going to come on to that in a second and look at that in a bit more detail. But even if you're not in a collective scenario, so you're not planning to make 20 or more people redundant, just the practicalities of consulting with employees, especially if they're on furlough or they're working from home remotely, is going to be a challenge that probably lots of us haven't come across before. And then the other alternative is, well, do you just need a stopgap? And do you have some employees who would welcome the opportunity to take unpaid leave or sabbaticals? So this is a situation where we've got a whole host of options available to us. So first of all, if we have a look at the furlough scheme, the scheme started on the 1st of March, and we now know absolutely it's going to close on the 31st of October. So the current rules that we're operating under will remain in place until the 30th of June, which is a month earlier than we'd initially been told. Early indications were that the current rules would remain in place until the 31st of July, but unfortunately that deadline has been brought forward. So from the 1st of July up until when the scheme ends on the 31st of October, there is going to be more flexibility. So it is going to be possible for workers to be able to return on a part-time basis. So this might be an opportunity for businesses to do a phased return for all staff, or if demand isn't there yet, to do some sort of sharing of the pain between your employees, to say, well, we can't bring everybody back full time, but we'll do it on some sort of rotation or some sort of part-time basis, so that you can maintain your employee numbers if you think in the longer term the demand will return and you can return to full operations. What you do need to be aware of, though, is that the scheme is going to close to new entrants from the 30th of June. So why on the slide do we say the 10th of June? Well, that's because after the 30th of June, you can only furlough those who have already been furloughed for at least 3 weeks beforehand. So if you want to continue to furlough anybody beyond the 30th of June, you need to make sure that they're on furlough from the 10th of June. If they've already been involved, I seem to be disappearing from my screen. If they've already been involved in the furlough scheme, then you can, then you can bring them in and out of furlough for the period from the 1st of July onwards. So if you are planning to keep furloughing staff, make sure everybody you want to keep and have the ability to furlough has been furloughed by the 10th of June. Okay, hope that's clear. If that's not, please post a question and I will run you through that again. But what's going to happen to the cost of furlough? Now, we know that employers are going to be expected to make a contribution to the cost. We don't know the full details yet. It has been described as a modest contribution, and we do know that from the 1st of August that the government will continue to pay 80% subject to the £2,500 cap. But the employers will have to meet the cost of NI and pension contributions. From the 1st of September, it will decline to 70%, and the employers will have to pay 10%. And from the 1st of October, it will go down to 60%, with employers having to contribute 20%. But that's just the outline. And what we don't know is what that 80% is going to look like. So, for example, if you have an employee who is on a £4,000 salary, if they come back and they work 50%, so they work part-time hours working 50%, then the employer will have to pay them £2,000. Now the cap is £2,500. So does that mean that the government will just top it up by £500 to the £2,500 cap? Or will the government pay 80% of the £2,000 that the employee isn't getting, because that's their non-working time, that's their furlough time? There's lots of questions like those about how the financial arrangements are going to work. Now, this is really difficult because on the one hand, I'm saying to you, we need to start planning now, but then on the other hand, I'm saying I can't actually tell you what the cost is going to be of continuing with the furlough scheme. And I appreciate it's really difficult because a quarter of companies that were surveyed by the IOD said that they wouldn't be able to afford even a top up of 20% if they were asked to. So these are really, really serious issues that businesses are going to have to consider. And it's also quite a difficult message to share with employees. To say the furlough scheme is still in place and the funding is there, but actually now we're potentially looking at redundancies because the business can't afford the cost. It's something we're going to have to keep an eye on, and it's something that we will keep you updated as and when these additional questions are answered. So please do subscribe to our updates. At the end of this talk, I'll point you in the direction of our coronavirus hub, where all of our latest articles are published to share with you as much information as possible. Right, so what's next? Asking staff to return to work.
We do have some questions, Elaine, actually.
Okay, yes, go far away.
So, what do you think the stance is on employees who have been furloughed due to childcare issues, who now have the option to send their child to nursery and come back to work, but they don't want to due to concerns over theirs and their child's health?
This is one where I think you do have to be really, really careful as to how you treat them. And in the majority of cases, I would advise, if you don't have to, don't take a point of principle on this and continue with furlough, because we are in such the early days of schools and colleges and nurseries, and there's so much noise, for want of a better word, from, for example, the unions saying that actually they don't consider that it is safe, that I think if you took a point of principle where you didn't need to say to employees, well, we're not putting you on furlough anymore because we expect your child to go back into school, there is a possibility that those employees could look at potential discrimination complaints to say, I'm being targeted because of my personal situation, and also potential breach of trust and confidence. So I think when you are considering furlough as a whole, you shouldn't necessarily look at one subset of your employees overall. I think you should consult with employees on a wider level to say, if you did the assessment and said, previously we have furloughed 80% of our staff, but actually now our business can come back to more full operations, and that means we have to remove some employees off furlough, you should have an open conversation with all employees to say, well, what could that look like? Who would be, some employees might want to return, some might not. And I think if you gauge it from a more neutral standpoint, rather than saying everybody with children who can now send their children to school. And I think it's also important to remember as well, it's not all children. So at the moment, it's just reception year 1 and year 6. So I would caution with that. But if you have a particular need, for example, if the majority of your staff have children and therefore they're all saying they can't come in and that is affecting you operationally, then I'd say let's have a chat, and then we can try and find you a safe way through. But I think if you don't need to go through that minefield yet, hold off if you can, and then see where we get to, because as you will have seen from the past sort of 9 or 10 weeks, the guidance is changing, and you may have done things following the guidance to a T, and then the government have done a 90 or a 180 on it. So I think if you've got the breathing space to see how this pans out, my recommendation would be to do so. Okay, thank you. And there's quite a few questions, so we might not be able to tackle all of them, but do get in touch if you'd like to talk further about this. So there's a few questions around the 10th of June date. What we understand is that you can't furlough after the 10th of June, so the scheme is closed unless you've commenced furlough by the 10th of June. So hopefully that deals with that point. There's a few requests for clarification around that.
And if staff went on furlough in April, have been brought back from furlough full time today, for example, can they be re-furloughed? Yes, they can. You have to do that for a period of 3 weeks in terms of rotation. So it's a minimum period of 3 weeks furlough. And then there's a question, if parents remain on furlough, but we have more work than employees at work, are we in breach of furlough rules to rehire people?
So when we say rehire, do we mean take new employees on?
I think so, yeah.
I think first of all, I think we should have a conversation with anybody who's on furlough to say we've had an increase in demand and we need to bring employees back, and test, because it's not just childcare. It might be that some of your employees are at home because they're living with someone who's shielding. So I think you should test across the workforce to say we need to bring back X number of employees and you are currently all furloughed, and we need to work out a way for this to work for everybody. So I think understanding why they're on furlough, what their situation and circumstances are, and what ability they have to come back. And then depending on how quickly you need to bring them back, this additional flexibility for part-time working might actually mean that, for example, somebody who has caring responsibilities, if they could come back part-time and they have a partner or family member who is also furloughed but could work part-time, they can share the responsibilities. So I think don't look at it narrowly, look at it across the board, and conversation and consultation and making employees part of that decision-making process is key, albeit that you will lead it and you'll have the proposal as to what needs to work.
Yeah, particularly if you've reduced pay down to 80%, so you need to think about how that will look to staff to start hiring people.
Yeah, I mean, if all staff refuse to come in, then maybe it might be that you look at agency staff. But I would be surprised if you wanted to go there, given that I think management of staff costs is going to be a key consideration for any business over the oncoming months.
Yeah, absolutely. We've had a few questions in about redundancy, so we are going to do a section on redundancy coming up, and I'm conscious of time, but if we don't answer your question, please do get in touch with us. So I'm going to just now look at asking staff to return to work and what that process should look like. So think about giving notice, reasonable notice. What does that mean? Well, unless the furlough agreement specified that you would give a specific amount of notice, which I doubt it would have done, then we're looking at reasonable notice, and you need to give as much notice as you can so that staff can make arrangements for things like childcare. Bear in mind, obviously, schools are not open to all children at all ages, so you do need to think about that. It's an awful lot for employers to be considering when they're asking staff to just come in and do their job. And then also employees might have got another job whilst they were on furlough. That was within the rules. So you may or may not know about that, but they will potentially have notice periods with their new employer. So we do need to think about that. Give the employee the opportunity to speak to their manager and address any concerns. They're almost certainly going to have anxieties about returning to work. So think about your communication around that and how you can reassure staff in not just the letter, but also ideally in meetings and in one-to-ones with managers. And think about the inability of staff to return to work, like we mentioned, with childcare issues. They might be in a vulnerable group, they might have particular health concerns. So you need to think about how you're going to deal with those requests. And we have helped a number of clients with the correspondence to staff about returning to work. So if you'd like a template letter, obviously do get in touch with us and we can help you with that. So the majority of staff will hopefully understand and return to work and get on with their work. You are going to have almost certainly a number of staff who are concerned, and you need to think about why they are, understandably worried about returning to work. The government's stay-at-home campaign was successful. People are now genuinely fearful about exposing themselves to the virus. Some may have a psychological fear of returning to work. They might be fearful of travel, and you know, the death rates in the UK are still high. So it's understandable that employees are going to have concerns around social distancing. We've all seen the press with the beaches that are full of people. So we need to really reassure employees that that you have processes in place and you're in control of the situation. The track and trace system is obviously supposed to be in place from last Thursday. It remains to be seen if the local infrastructure will be able to support that, and it's going to rely on the cooperation of the public when the trust in the government, shall we say, is a little on the low side after things like the Dominic Cummings affair. So you do need to talk to your staff about why they don't want to return to work. If they've been working from home rather than furloughed, then they might say, well, why can't I carry on doing that? Which is a reasonable question to ask. Now, your risk assessments are going to be really important when you're addressing the risk with staff. Look at the government guidance also, particularly for anybody that's vulnerable, that ought to be staying at home as much as possible. They have to minimise contact, and you should think about, is there work that we can give them where they are going to be away from people. Try and agree it with staff as far as you possibly can. Consider if what they're asking for is reasonable. If it is, then you should be doing it. If you've got some concerns around being able to comply with their requests, then do get in touch for some advice around that. It might be that you're able to consider something like unpaid leave. You would need agreement for that. You might even be able to, as a last resort, consider dismissal, but obviously we want to try and avoid that, not just because of the litigation that might follow, but thinking about PR and morale. But do ask for advice around that. You have to be very careful. Employees have a number of rights, and some of which Elaine will be going through in the next few slides.
Okay, we don't have any new questions, so I suspect we have covered that with some of the earlier questions. So I mentioned at the outset that potentially we have this emerging line of litigation around health and safety, and I say it's an emerging line. It's always been there. There's a section in the Employment Rights Act where employees and potentially as well the wider group of workers are protected from being subject to a detriment, which could be suspended or having their pay reduced, or indeed being dismissed, if they exercise a right to leave their workplace because that they fear there is circumstances of danger which puts them in serious and imminent harm. If we breach this protection, so if we subject an employer or worker to a detriment or to dismissal, it's an automatically unfair dismissal, or rather if we breach this and we dismiss them, it's an automatically unfair dismissal. So a little bit like whistleblowing cases, they don't need a qualifying period of service, so it's everybody from day one. If they are dismissed because they leave the workplace and refuse to return, they can bring an unfair dismissal claim, and because it's an automatic unfair dismissal claim, compensation is uncapped. Now, if we subject them to enough of a detriment and they resign, that is also captured, so the constructive dismissal claim is also captured as an automatically unfair dismissal. So what does this mean? There has to be actual danger. It can't be an idea or perceived, it has to be actual, and that is an objective test. And the danger has to be serious and imminent. Now, that isn't a subjective test, that isn't an objective test, that is a subjective test. So what is in the mindset of the employee, albeit it has to be reasonable for the employee to believe that. Now, the difficulty with coronavirus is, if you look back through a lot of the government's updates, they have, and I don't think they would have thought about it at the time, referred to COVID as being serious and imminent threat to public health and well-being. So the kind of language that we've seen in terms of the government announcements and public health announcements reflects the language that we've got in the Employment Rights Act. Now, as I say, I don't think that was intentional at the time, and it's certainly not definitive, but in terms of, is it reasonable for an employee to believe that they are at serious and imminent risk? Well, yes, because that is what the government is telling them, or rather most likely. Now, the difficulty that we have in applying this set of case law that we have so far is that it's never dealt with a case with the risk of infection, or whether that is in the workplace from our workers and employees, colleagues, or whether it's how they get to work and using public transport. So the limited number of cases that we have on this section of the Employment Rights Act is generally there is a physical danger within the building, whether that's the building itself, for example, there's a fire, or whether that's because there is the threat of violence, for example, from another employee, and the worker or the employee takes themselves away from that, goes home, and then refuses to come back in until the employee who has been threatening them is dealt with or the situation is addressed. So we're taking a line of case law and we're trying to best understand how this legislation is going to be interpreted in the case of the COVID pandemic, which is why the last bullet point says there is going to be case law on this, but it's going to be groundbreaking, and it's probably going to get a lot of publicity. So would you like to be part of it when we're not quite sure how that's going to go? And we include that. I mean, if you want to be a test case, I will quite happily stand by your side in that. But the reality is you probably don't, because it is likely there will be negative publicity around that. So before you start to deal too stringently with any refusers who are coming back in, it's really important that you take advice, because I mean, just where we've got to so far in this presentation in terms of potential discrimination complaints, you know, having to complete risk assessments that are much wider than we've ever seen them before. There are so many different facets to dealing with the situation if an employee is refusing to come in. And now on top of that, we introduce a new line of litigation that they could bring. It's really, really important that you don't react too quickly. We don't have any knee-jerk reactions, and we factor in all of those potential possibilities and mitigate against them as much as we can if there is an issue with some or you know, one or two of your employees who are just refusing to come back into the workplace before we take any action in relation to them. And part of that is going to be about, have we made sure, as Helen explained, that we've done the risk assessment and we've done some good consultation with them around not only the dangers and the arrangements we've put in place, but what their concerns are and what it is that's holding them back from coming in, and what are the other options. For example, is it possible for them to work from home? Okay, have we got any questions come through on that? Because I know that is, I mean, I could do a whole session on just what those provisions are and where the litigation will come in. So have we got any questions on those?
We have, so I'm going to summarise them just because I'm conscious of time and I want to make sure that we get through to things like change in terms and redundancies. So here's a summary case example. So our office is returning, nobody uses public transport, everybody drives, we've done the risk assessments, no one has been furloughed, but we do have one member of staff who doesn't want to come back, the reason being childcare. And her parents are over 70 and her husband works in IT and is seen as a key worker. So how would you deal with that, Elaine?
I think that's interesting. So what they're not doing is saying that they're not coming back in because they're worried about the risk of returning to work. And it sounds like in some ways you're in a better position if you haven't got to factor in public transport. So your risk assessment is about your environment and what you can control, and it sounds like if you haven't had anybody, you know, you've remained operational, so you should hopefully be on top of everything in terms of the social distancing, all of that preparation. So if that employee is saying I can't come back in for childcare, then you can look at alternatives for that individual to say, well, if there isn't, you could furlough, and you can continue that. If that isn't an option, then you could start to look at, can she take some holiday? Can she take some unpaid parental leave? There's lots of options for people who are struggling to come into work because they've got caring responsibilities. So have a look at, firstly, at your own policies and procedures to say, if we weren't in a COVID situation and your employee was saying they were struggling to come into work for childcare, what options have you got? And how do you pay for those if you do over and above the statutory schemes? If that doesn't work, have a look to see whether you could furlough them. You'd have to factor in the costs as and when we know how that changes. But I think in some ways that's a slightly easier one, because they're not saying you're not coming in for health and safety reasons. They're saying my child can't go back to school and I need some time away from work. And I'm assuming in answering that as well that some sort of home working isn't an option. If home working was, I think we'd need to consider that as well.
Which leads us nicely on to thinking about changing terms and conditions. So every time you ask an employee to do something differently, for example, when you place them on furlough, that's obviously a change to their employment terms and conditions. So now we need to think about what sort of changes might you need to make moving forward. And when you've assessed that, so it might be that you unfortunately need to think about pay cuts or reduced hours or different ways of working. So the starting point with any variation is, do you have a contractual clause already in the employment contract that you can rely on to make that change? And it's known as a flexibility or a variation clause. So you would need to look at that wording and think about, what does that allow you to change? Do you need to give notice? What process of consultation do you need to follow? And if you are relying on a flexibility clause, then that clause, it's really important that it must be drafted clearly and unambiguously, because any ambiguity will be interpreted against you. A general flexibility clause that a lot of contracts have won't be good enough to make changes like pay cuts. So even if you do have that unilateral right, then you do have to exercise it in a reasonable manner, which usually means thinking about notice and consultation. It will really depend on what sort of changes you need to make. Like I say, it might be a change of job duties, like the case study that Elaine was just talking about, maybe a change of location. So think about the risks to the business. Do take advice if you're not sure if you've got the right to do it. The risks are potential breach of contract claims, constructive unfair dismissal if the employee has 2 years or more service, and potentially indirect discrimination claims if the changes disproportionately impact a particular group of employees. So if you don't have a contractual right to vary, then you need to try and agree the changes with staff, or you may have a recognised union and you will have to go through collective bargaining to reach agreement. So ACAS has got some guidance around this, which is worth having a look at, and it points out that consultation really needs to be a genuine two-way process. Ideas should be shared and worked on together. The employer must be explaining the reason behind the change, invite employees to talk about their concerns, suggest ideas for alternatives, listen to concerns. That's really important, that you're seen to be genuinely listening, and consider their ideas. Try to resolve concerns, and if you get agreement, great. You must confirm that in writing. That's a Section 1 requirement. If you can't reach agreement, then again there's a process to go through, and it is possible to look at dismissing and rehiring or re-engaging on the new terms. But that really ought to be a last resort. If you've not done it before, you really ought to be taking advice on it. And only after consulting the employee and going through that consultation process can you look at dismissal as a last resort. If you are thinking about that option, then make sure that you've done everything you possibly can to try and reach agreement. Think about all possible compromises. Are the changes absolutely necessary? So it would have to fall within a potentially fair reason for dismissal, known as some of the substantial reason. Have you followed a fair dismissal process? Have you given the required notice, either statutory or contractual? And have you offered the employee a right of appeal against their dismissal? So, like I say, it's a pretty tricky process to go through, so do think about getting advice around that. Tone of communication is absolutely critical. You really do need to think about how you're explaining the need to make changes, and obviously try to avoid using threatening language. Staff should understand the difficulties that the business is facing and hopefully will want to keep their job. So if these changes avoid redundancies, then hopefully you'll be able to get agreement, but we can support you with that process if you need assistance.
Okay. Don't think we've got any specifically on contractual variations. So if we go ahead and if we look at collective consultation, that might actually provoke some in relation to both because they fit quite nicely together. So as Helen said, if you are, you may trigger the collective consultation requirements even by negotiating terms and conditions, and that's because if you are looking to change terms and conditions of employees at the outset, it might be difficult to anticipate how many dissenters you'll get, and presumably in the majority of cases where you're trying to change terms and conditions, if employees don't agree to that, then the option, as Helen said, is dismissal and re-engagement. So because you can't predict the number of people that will not agree to the changes, and therefore you can't with any sort of certainty say it will be less than 19 people who you might have to dismiss, it could very easily be 20 or more. So at the outset, actually, you could be in a collective consultation process, and most people think that that just relates to redundancies. But the reason that it relates to changing terms and conditions is because under some of the legislation which is applicable here, redundancy isn't the narrow place of work closure, needs for fewer employees, etc. Redundancy for the purposes of collective consultation is any dismissal which isn't related to the individual concerned. So if you are changing terms and conditions for everybody, that's not related to one individual. So any dismissal as a result of that will trigger the redundancy definition and therefore trigger the collective consultation obligations. So just something to bear in mind, if you've got 20 or more people that you're proposing to change their terms and conditions, comply with the collective consultation obligations. So what does that mean? It means that you have to engage with employee representatives first and foremost. Now, a lot of people, in my experience, the moment that I mention collective consultation, do this huge sigh and look like they're about to, I'm about to put the thumb screws on. But actually, collective consultation a few years ago was made a much simpler process, so that the length of time that you have to consult for was reduced. So if you're looking at 20 or more redundancies within a 90-day period, it's 30-day consultation. If it's 100 or more, then it's 45. Those periods used to be much longer, and it was difficult to manage. The reality is, if you are making 20 or more people redundant, or you're changing terms and conditions for 20 or more people, it is most likely going to take you 30 days anyway. So it isn't a longer process to comply with collective consultation. The fact in the early days that you consult with representatives who are then your voice and do the dissemination, the filtering of information for you, makes it easier. So actually there's lots of positives, and you have a designed procedure that you follow, and employees and the representatives will know about that. So try to see collective consultation, if you have to go through it, as a potential positive, because the alternative is you've got to sit and meet individually 20 odd people and canvass their views and try and bring it all together. Aside from the fact that I think actually it's an okay process to follow, the other reason you should, if you just don't believe me, is that if you don't, employees can bring a protective award claim, which is up to 90 days gross pay per affected employee. And that's not based on any losses that they incur. It's a penalty for the employer for not having gone through the collective consultation process. Okay, but hopefully I had you on my explanation. So if you've identified, if you're sitting here now and you're thinking, yes, that will be us and we're in a collective consultation process, what does it mean? Well, first of all, have a look to see whether you already have elected representatives in place. Do you have a works council that their remit covers the negotiation of terms and conditions? Do they represent everybody who is affected? So first of all, if you do have reps, don't assume that they are the properly appointed reps for this process, but check, because they might be. If not, and you're going to have to go through an election process, then you need to think how you are going to consult with your employees if they're not in your workplace at the moment. So it might be that they're home working, or it might be that they're furloughed, they might be on some sort of unpaid leave. Factor that in, because it will take longer. And your duty to consult, the communication rhythm that you would normally have if employees were in the office might change to take account of the fact that they're outside the office. So I don't know what you currently have in your businesses, but if you have things like WhatsApp groups or, you know, Teams groups, Teams chat, think about all of the different communication channels that you can use which suit the fact that employees are out of the business at the moment. You know, sometimes bite-sized letters rather than 2 or 3 pages might work better and might help with engagement. I've got some clients who've even done videos just to explain what's going on. Rather than send a 2-page letter, they've sent a 5-page video. And it gives it that personal touch as well. So we're in a different environment. Use what will work for your business to make sure that you have employees who are engaged in the process. At the bottom of that slide there, we mentioned the special circumstances defence. And then you might have seen, if you read things like HR Director or Personnel Today or People Management Magazine, whether coronavirus offered a special circumstances defence for those businesses that had to make redundancies very early on. What the special circumstances defence means is that there's an acknowledgement that you should have complied with a collective consultation process, but the thing that affected your business, which in this case is coronavirus, was so immediate. If you suddenly, you know, if orders suddenly dropped off a cliff, there just wasn't the time to comply with your statutory obligations to collectively consult. That is highly unlikely to be effective here, because furlough offered that breathing space. So the threshold to succeed in a special circumstances defence was always very high, because tribunals didn't like it. The fact that we've now got the furlough scheme, which allows some sort of breathing space, means it's going to be even harder to reach that threshold. So, collective consultation problem areas. This is some good news for you. So if you have got employees out on furlough, we already know that those employees can act as employee representatives, and there's no breach of the no work rule for the furlough conditions, and also that you can consult with furloughed employees about their personal circumstances and the fact that they might be at risk of redundancy. So there's no breach there. Okay, over to you, Helen.
And then in terms of the timing of redundancy and unfair dismissal, so big issue for employers, when do you look at having a redundancy process? And unions are already starting to argue that the job retention scheme should be utilised to preserve jobs in the short term. So do think about your timings and get advice if you're not sure as to when you should start that. In terms of notice then, so the usual rules apply. Employees are entitled to notice prior to be made redundant. You can serve notice during furlough. Now you may be able to base notice pay on reduced furlough pay, but it depends on the type of contract. So do take advice if you're not sure about that. And you probably can use the furlough grant towards notice payments, but again, that's something that's quite complicated. So do think about getting some advice around that. In terms of redundancy pay, so you might be able to base payments on furlough pay, but we are advising that the safest course of action is to base it on pre-furlough pay. Again, that is something that we can assist with. And finally, you can't use furlough grants to meet redundancy payments, so we are clear on that. So as you can see, there is a fair amount of uncertainty still. So that's something we can support you with.
Okay. And then just to, oh, the slide's slightly behind, just to wrap up then, because we are coming up to our hour. Thank you everybody for attending. We have done a to-do list to give you a snapshot of what you need to be thinking about now as you come off this call. So conducting a COVID secure risk assessment, consider the impact of employees returning to work, particularly those who are vulnerable or in at-risk groups, giving notice for employees to return to work, and how you consult with them about that, and also factoring in enough time to collectively consult if you are looking at changes to terms and conditions or indeed redundancies and restructures. In the Q&A chat, we have just posted a survey link because we've got over 200 people on today's session, and we're running these events across through all of our regional offices, and we've got over 1,000 people. So what we'd like to do is get a snapshot across sectors and geographies to say, well, what is happening, what's the impact on your business, and it will help us firstly to determine what further of these sessions we need. We've had so many Q&As being raised during this. We've tried to get as many as we can, but what we could do if we review all the questions that are raised is identify, you know, the appetite for further subjects for more webinars. But also it helps us to, we consult with a lot of and feed our comments into a lot of the government bodies to say what we're experiencing and what they need to do, or what problems are coming up and where we need further guidance. So there is a bigger picture as well. So please do fill that in. We've tried to cover as many of the questions as possible. If you haven't had your questions answered, or if there was a question that you didn't want to really raise in a public forum, please do fill them in afterwards. And what we will do is try and do some callbacks with you if that will help. So please note if you'd like a callback, if there's something that you want to discuss and there's something that we can help with. I'm also just trying to move the slides across because we also have a coronavirus hub, which includes all of our latest commentary or breaking news as and when we get guidance. There's an awful lot of resources on there as well that can help you. They're all free, they're available on the website, so please do use those. My thanks again to Helen for co-hosting with me, and also for Michael Page for helping promote the event and for partnering with us. That's it for us today, so thank you again for attending, and we hope to see you at our future events. If you have any questions, any feedback, please use the events at Irwin Mitchell website. But thank you everybody.